Well, good evening, everybody. Jonathan here. Hope you all are having a nice uh, late afternoon, early evening. Been actually an interesting week. Had several hearings. We got actually all favorable decisions on them, even from some judges that are have pretty low percentages. And again, it's just a matter of does the medical support it, and you could judge it's reasonable, and it seems to work. So that's cool. That's good. So let us go directly into the questions or the comments here. So Jenny says hello. Hello, Jenny. And Michael Hale says, glad to see another great video. Well, we'll see if that turns out to be the case. Hopefully it will be. Julie says, hello, everybody. Hello, Julie. And Jenny has a question. At the Recon stage, does SSA consider all new medical evidence, even issues, body parts not mentioned in the initial application, especially if relevant to functional capacity? Very good question. Answer is yes. Basically, at initial and Recon, you can bring up new medical issues. If you include them in your paperwork at initial, that would be considered. You can bring up something new at Recon. It's going back to the state agency. If you go to the hearing stage, though, and you want to bring something up new, many judges will not consider something new at the hearing stage. Some will, but I've had cases, and these are many, many years ago, where the judge said, you didn't raise it at initial Recon. We can either proceed with the hearing and not consider those new issues, or I can send it back to the state agency for an evaluation. So that has not happened to me recently, but it did happen in the past. So I would tell you, if there's anything that you're aware of that would be an issue as far as you're working, raise it at initial, raise it at Recon. If there's something new, after the Recon, then what I would do is I would let the judge know that in a pre-hearing memo, and then let the judge know this is something new and kind of just lay it out for him or her. But the possibility is it would go back to the state agency, maybe. But yeah, you can bring something up at Recon. So that is a very good question, and that is that's the answer to it. Trish says hello, Trish. K Wolf, these are people that I know are those guys. Says engines revving. These are people that I've seen before. Spectators, okay. G.I. Jose, Joe, called DDS today. They really wanted me to fill out a function paperwork, was told 90 days or so for decision. They seem to have no idea what condition you're applying for. Again, I think the more information, Joe, you can give them, the better. The function report will certainly set that out. Don't hesitate to simply write them a letter and explain what the medical issues are. People get very hung up on the forms, and I understand that, but not everything has to be in an official form. If you have medical issues, and again, the issue is not the diagnosis, the issue is, how your medical issues would prevent you from being a reliable employee. So that's what you want to focus on, and that's what you want to tell them. And if you have to do that, I've seen people write, letters that they'll attach to their function report. It'll be a 6 or 7 page letter where they go into great detail. And I'll reference that in my brief. I'll say, the claimant described his or her functioning in great detail at Exhibit 5E, pages 7 through 12, and reference that. I use that when I'm preparing my case, so you can certainly do that if it's not on the form. So just don't hesitate to write them a letter if you need to do so. That way they've got all that information there. And of course, you want to tell them who the doctors are, and you need to be aware of your insured status. So, when you stop working, your insurance follows you for about 5 years for SSDI. So if you're applying for SSDI, you got to make sure that the medical information showing that you're disabled goes back to before your date last insured. Otherwise, you're only going to be able to pursue SSI. SSI has limitations in terms of income and resources. You cannot pursue SSI if you have more than $2,000 of assets. There's some exclusions, or if you have household income, spouse working, that is really more than poverty levels. So make sure you know which program you're applying for as well. Hello, George. Hello, Maria. Julie said she called the office today. I was actually in hearing, so I didn't really take any client phone calls. I hope that you either talked to Madeline or you gave the information. We'll make sure that we get back to you. I was, like I said, I was pretty tied up. I um, had a hearing today that was a complicated case. Actually, the person who I did the hearing for is on comes to the live stream sometimes. I hope she'll be there tonight, and she can tell you about her experience. But she actually had some really interesting input about how to prepare for a hearing and what we did, what she did. I'm going to actually incorporate that into my my presentations to my clients, and I'll go into that in a little bit if you guys would like. Julie says, is it better to apply with an attorney initially? There's mixed, I would say it's a mixed bag. I mean, you don't have to, and I always make it very clear to somebody, if you don't want to apply with an attorney, it does not offend me at all. Go ahead and apply and see what happens. If you get approved, then you don't pay any attorney's fees, and you pass go, you get your money and move on down the road. Realize, by the way, that the first 5 full months of disability, there's no past due benefits. So for example, I've got a case right now. I was talking to a client. We filed the application. She actually was a person who needed a liver transplant. She got the transplant. Things have gone really, really well. And she's going to go back to work probably in January. Well, there may not be that this all may happen within the 5 months. We may not see much of any past due benefits. So she said, she emailed me today. She was, how do I pay you? Like, you don't. If you get approved within 5 months of your onset date, then there's no fee. Basically, I told her, I said, write me a nice review, and that would be fine. So sometimes I take cases that are clearly winners because I just want to, a person needs to get benefits, and if I can, help that person, the nice review is fine. But as far as applying with or without an attorney, some people feel more comfortable having me do it just because we've done a lot of them. Other people, it's 65, 70 questions. They feel like they can do it themselves. I will tell you, unless you've got like in this lady's case, a liver transplant, I mean, you have something really, really serious, they're probably going to turn you down. So it's probably not going to make a difference in the end. But I always tell people, I don't mind if you want to try it on your own and call me if you get denied. Because look, I mean, 25% of past due benefits, still money coming out of your pocket. And if you can do it on your own, I have no problem with that. Or if you feel like, I'd rather have the guidance, somebody doing it for me. I'd rather have help with the forms they're going to send me, that, all the function reports and all that stuff, which is what we do. Have somebody you can call, that's fine too. So that's entirely up to you. I don't tell anybody that, you absolutely have to do it with an attorney. I think we add value, but how much is up to you. I would not go to a hearing without an attorney, but doing initial, it's your call. Recon, same kind of thing. It's pretty simple form to do. You're probably not going to get approved at Recon. So if you bring an attorney in at Recon, it's probably not going to make a difference as far as whether you get approved or not. So I would tell you Recon probably makes sense just to go ahead and get somebody online, just because you're probably not going to get approved at Recon anyway. So, okay. And Sparkle, hello, Sparkle. And yes, we have the free case evaluation. I've got that running. Jeff, how are you doing? Jeffrey is an attorney friend of mine in Scottsdale, Arizona. I'm going to have him on. I told him, I said, anytime you want to come on, I'll send you the link and you can come on and answer questions too. So Jeffrey is posing the question. And we've talked over the time. We actually met at a conference here in Atlanta, I think earlier this year, or maybe late last year, I can't remember. But Jeffrey has a law firm called Desert Disability I know it's in Arizona. I think you do some other states as well. Very capable attorney. And again, one of the people in my network of attorneys that I would call if I had questions for. So his question though, or his comment, have you ever subpoenaed witnesses to testify? I have never subpoenaed a witness. I've had witnesses. As you know, it's pretty uncommon to have witnesses testify. Usually if I'm going to have a witness, it's going to be a family member or a friend or maybe a former coworker who comes voluntarily. I've had doctors come and testify. I've had social workers come and testify. I've never subpoenaed a witness. I'm not sure that the Social Security judge has even the power to subpoena. I know that, this issue has come up before, not as much now because we've got, better ways to get medical records, but years ago, we would have sometimes difficulty getting medical records from providers. And so, we would ask the judge for a subpoena. And there was some debate about whether a Social Security judge, being an administrative law judge, part of the executive branch, has the power to issue document subpoenas. Um, arguably they do, but I don't know if it was something could be challenged in court. But I've never done it. Again, if you have a witness that you feel is that important to your case, it's certainly worth a try. But if you're talking about subpoenaing that witness, that suggests that that witness maybe is not being as cooperative as you want. So, that's an issue. I think the other thing is, again, as you know, Jeffrey, the hearings last 45 minutes, an hour. Are you going to have a judge wanting to listen to, 15 or 20 minutes of testimony from a witness? If it's a doctor, maybe. If it's somebody who has something really unique to say, maybe. Then you get into the question of, do you have to pay the doctor? And if you don't want to pay the doctor, $300 an hour, is he going to be upset? So, those are sort of things. So my answer to that is, I think you probably can, but I tend to have people come voluntarily. I have never personally subpoenaed a witness. So that's my take, and you maybe have a different insight. Maybe somebody else here has had a different experience, but that's mine. Okay, Calvin, is Lyft or Uber considered a sedentary job? It's a ride share, and actually that's an interesting question because the question, the resource that Social Security uses is something called the Dictionary of Occupational Titles, which was last updated in, I think, in 1990 or something, and needless to say, there was no such thing as Uber or Lyft. Let's see what taxi driver. I'm guessing that taxi driver is the most comparable type of thing. Taxi driver. Let's just see what the DOT says. Taxi driver is. We got a lot of taxi cab, taxi driver. Here we go. Okay, it is showing up as a medium job. I guess because taxi drivers sometimes have to lift luggage. So, I know when I've taken Lyft or Uber, sometimes the driver will help get my luggage in the car. I would think that the vocational witness would probably treat this the same way that he or she would a taxi driver. So it's probably going to be considered at least a light job, if not a medium job. So I don't think it would be sedentary. But that issue has really never come up, believe it or not, although I have a lot of clients who do drive Lyft or Uber, but their earnings are typically not enough to really constitute substantial gainful activity. One of the things that when a judge is talking to the vocational witness, you have to have been working at a job long enough and making enough money for it to be substantial. So, for example, if you have a skilled job, let's just take a executive secretary job. Let's say that's a skilled job, and you've only done it for 2 months and you have to stop. Vocational witnesses will say you have not done that job long enough to acquire the experience to really make that a past relevant work. Relevant being the operative word. So I think with an Uber driver, a lot of times when somebody's doing it part-time, and I've got plenty of people doing that, they don't make enough money that really ever counts. And I don't recall ever having a vocational witness or a judge ask a vocational witness about an Uber driver as past relevant work. But again, my guess would be it would be considered either a light or very possibly a medium job, because that's what taxi drivers would be. But that's actually a very good question, Calvin. I appreciate that. Mango bomb squishies. Now, there's got to be a story behind that. I'm not going to even ask, but okay. I've watched all videos, and to get my diagnosis at an autistic level, it's 11 to 15 on the on a scale over 7 is severe autism. Do I qualify for just that? I always tell people, let's take a look at the let's take a look at the listing and see. I think I would say this: every listing has a component of functional capacity. So let's look at the mental listing, which is where that would be. And let's see if there's anything with autism. I'm not seeing it. Let's just see. Autism spectrum disorder 12.11, neurodevelopmental disorder. And let's take a look at what it says. And this seems to be the one that is most relevant to your question. So give me 1 second here. Okay, so I believe autism, and this is the listing, realize that you can win based on listing, or you can win based on a functional capacity argument. Neurodevelopmental disorder, and you have to satisfy A and B. So A is the symptoms: frequent distractibility, hyperactive impulsive behavior, significant difficulties learning and using academic skills, recurrent motor movement and vocalization, and extreme limitation, extreme being the operative word, to understand, remember, and apply information, interact with others, et cetera, et cetera. So I think my answer to you would be that the diagnosis alone is not going to be enough. You've got to show functional issues in terms of not being able to function, appropriately, not just in daily living, but in a work-like environment. So, what I would probably do would be to, sit down with your doctor, your psychiatrist, and see if the doctor felt like your level of function, or the limitations of functioning, are equivalent to what is in listing 12.11. And again, just go to meetalisting.com, meetalisting.com, and you can click on the link and you can see the listings. But I think this is the one that would apply. And so, if you don't meet the listing, the next step would be a functional capacity argument, where you would basically say that the limitations arising from, being autistic, difficulty interacting with others, picking up social cues, maybe oversensitivity to stimuli, things like that, those things would make it difficult for you to perform reliably even a simple entry-level job. So that's how I would approach it. I would say, look at it as possibly a listing level case, and then look at it as possibly a functional capacity argument or limitation based on the sort of the constellation of symptoms. If you're on medication, then what are the side effects of the medication? If there are third parties who have observed you trying to work, who know you, who could talk about the limitations that you have in terms of functioning, interacting with others, performing tasks, reacting, if you get overstimulated, things like that, losing, not being able to handle pressure of work. Statements like that would be very, very helpful as well. So that's how I would approach it, both as a listing and as a functional capacity type of argument. But that's how I would deal with that. But the diagnosis alone is not going to be enough, is my take. Julio, thankfully Medicaid paid programs do its justice. SSA should be audited for the human errors. DDS is my best friend for CDRs. Okay, I mean, again, Social Security does not have enough people. I think, as I've told you, I think let's go back to Mango Bomb, because she said here, I've already applied. The neurologist wrote active bipolar, ADHD, and hallucination. Yeah, look, hallucinations that's something that I've won a lot of cases with, because if you have hallucinations, you cannot distinguish between what's real and what's not real. That is inherently going to be a problem in a job. So I think it sounds like you're doing, the right thing with you having a neurologist really address some of the issues that would impact you kind of on a day-to-day basis. So I think you're headed down the right track, is what I would say. All right, so going back to Julio, as far as them being audited, they don't have enough people. And again, the commissioner, Martin O'Malley, spoke at the NOSCR conference back in May. I was there, and he's really done a good job. I mean, he's an administrator by profession. He was a former mayor, I think, of Baltimore, former governor of Maryland. So he kind of jumped in and really took this very seriously. I mean, he was really has done a really good job. And he recognizes they don't have enough money. In fact, he's testifying before Congress, I think this week or next week, and he's going to tell them again he doesn't have enough money. The problem is there's no motivation in Congress to allocate the money that Social Security needs to hire more people. And the reason why things take so long is they don't have enough, funds to hire and train people. The training can take about a year. They have a terrible attrition rate because the work is very thankless. They're overworked, underpaid. They get poached a lot. The VA poaches a lot of their people. They have a lot of people quit during COVID. There's been kind of an ongoing simmering dispute between the employees union and management about working at home. So it's kind of a mess. And, again, O'Malley knows it, but there's not much he can do about it. He'll be gone, as of middle of January, January 20th, I think is his last day. So we're going to get a new commissioner. I'm not holding my breath that the new commissioner is going to be anything close to as claimant, oriented or friendly or responsive as Commissioner O'Malley. You never know. But, I've said this many times on this live stream. Congress, there's a narrative in Congress that people on disability are all exaggerating or faking it. And, they just feel like, especially when you have invisible illnesses like depression, anxiety, like autism, they feel like, it's very, very hard to pin down to know for sure whether a person has work limitations. And so, what they do is they think that judges are too lenient on awarding benefits to those people. And even people with back issues, having a herniated disc doesn't mean you're disabled. They feel like, that there's just a undercurrent of people exaggerating and faking it. So there's really not a lot of motivation to fund Social Security to make the program more responsive or to work better. I mentioned this before. I interviewed a gentleman named Spencer Bishens on my podcast at ssdradio.com if you want to listen to it. Spencer used to work for Social Security, and we talked about the delays. I'm going to see if maybe I'll get Spencer on here because he's got some good insight. But he said basically, he goes, the reason why the system is so backlogged is because that's what they want it to be. They don't want it to be efficient. They don't want to make it easy for people to get on disability. That's a very cynical approach, but he worked there, so he has that's his take on it. So I don't see. And then finally, people pursuing disability. It's not like the AARP, represents millions of people collecting retirement Social Security, so they're a voting bloc, and they have a mechanism, a vehicle to communicate with those people and tell them to vote. Nothing like that for disability. People on disability are not a voting bloc that that you can communicate with. So there's just not a lot of incentive for Congress to do much. So you said they should be audited for their errors. I mean, the errors are because they don't have enough people and they don't have enough proper training. So that's the deal. Okay, Julie. All right, so we'll check on that. Thank you. Question or talk about doctor visits. Let me see if you got. I filled out the forms I was scheduled for doctor appointment regarding my disability claim. Okay, so basically, what George is talking about is when you apply for benefits, many times, not always, but many, many times, Social Security will send you out for what is called a consultative evaluation. This is with, there are doctors on the panel. They have doctors that do this to make a little extra money. They're either going to be physical medicine doctors, internists, typically industrial clinic level doctors for physical, physical issues, and then they have psychologists for mental health issues. They will also occasionally send somebody out to a specialist like a cardiologist or ophthalmologist as well. And by the way, next week, I believe I'm going to have a doctor, I keep drawing a blank on his name, the doctor who's got the YouTube channel about consultative evaluations, J. Dave, and I'm terribly sorry, I can't remember his last name. But anyway, we communicated, we spoke this week. Let me find it because I'm embarrassed I forgot his last name. But anyway, he's going to be on. He said he would come on next week. Let's see, Dave is his YouTube channel. There we go. Foster, Dr. Foster, John Foster. I mean, his YouTube channel calls it, says J. Dave Foster. So I'm not sure if he goes by John or Dave. I thought it was Dave, but when we communicated, he referred to himself as John. But Dr. Foster will be on next week for I'm not sure how long. I told him as long as he wants to, and he'll answer questions more about the consultative evaluation and what they do. The big picture is Social Security has the obligation to develop the record and to make sure that the record contains at least some evidence about your condition that you're asserting. And so, what they've interpreted that to mean is they've got to send you out to one of their consultative doctors. And some of these doctors are just not very good. And some of them, like Dr. Foster, and if you look at his website or his YouTube channel, just go to JDave, all one word, Foster, JDave Foster. And he's got a lot of really good videos about, what a consultative doctor is looking for. I would say Dr. Foster does it a lot different than a lot of the doctors that I see in consultatives. I've read many consultative evaluation reports that are worse than useless. They don't say anything other than the claimant reported this. They don't draw any conclusions. So, he will explain to you what he looks for and kind of the common mistakes that people made. But, these exams, most judges do not give them a lot of weight, although the judge is allowed, if the judge wishes, the judge is allowed to, give a consultative evaluation report controlling weight and make a decision based on that. So literally, you could have treatment records from a doctor who's seen you for 5 years, performed 3 surgeries on you, dealt with you with rehab and all that stuff, who knows you extremely well, and who has a very strong opinion about your capacity to work. The judge could say, not going to deal with that, but I'm going to take this one guy who saw you for 45 minutes 2 years ago, I'm going to take his conclusions and deny your claim. They're allowed to do it. Most judges aren't going to do that, but they are technically allowed to do that. So, again, Dr. Foster will explain to us kind of more about the consultative report, and what the doctors are looking at. But again, this is, he's going to tell you more about the mistakes that he sees and ways to make that report or that consultative evaluation work better for you. So I would definitely tune in next week for Dr. Foster. Is it legal to pay your primary doctor to fill out a form? Yeah, I think it is. And by the way, Mango Bomb said that she's still on step 3, which means the case is being evaluated. So it's not been decided yet. Okay. Is it legal to pay your primary doctor to fill out a form? Yeah, you can do that. A judge might ask you, did you pay the doctor? Now, again, does that matter? Probably not. I mean, I think that, the doctor is going to fill out the form based on what the medical evidence dictates. I do believe that if the attorney sends the doctor the form, what I do is on the bottom of the form, I'll say, please return this to Jonathan Ginsberg with my address. So I'm not trying to hide that I sent the form out. But, technically, I don't know that you have to, if you paid the doctor $100 or $45 or $200 to fill out the form, I don't know that you have to reveal it, but if the judge asks you, you got to tell him. Okay. All right, so if they do approve, you originally applied in 2015. All right, so we're getting into, and I'll just touch on this a little bit. What Mango Bomb is telling us is that she applied back in 2015. I'm guessing you were denied, you've reapplied, and you want to try to reopen an old application. That is very hard to do. There in a disability SSDI case, there is an opportunity if you reapply within 1 year of the denial of claim 1, you can ask the judge to reopen that for any reason. If you don't do that, if it's been within 4 years, you can do so, but you've got to have a really good reason. I think anything beyond that is going to have to be extraordinary. You're going to have to show that Social Security completely misled you. So the reality is, it's probably not very likely that you're going to be able to go back to 2015. I had someone email me this week, and she said that, she wanted to try to argue that she was to say her date last insured was in 2003. And she wanted to argue, apply for benefits and say, well, I became disabled in 2003, so I can get disability benefits. And I just said, it's going to be really almost impossible to do that. Finding the records, convincing a judge. So I think that's going to be a real uphill battle. Unfortunately, I just don't think you're going to have a hard time finding a lawyer who will take that. Not impossible, but I think it's going to be really hard. Realize they limit our fees. They cap our fees. So, something like that is going to be extremely difficult. It might require, depositions, things like that. So it's going to be really hard. Okay. All right. Kelly asks, what's the best way to build your case if you have depression, anxiety, and PTSD? Doctor will not fill out functional capacity forms. Well, first of all, I would tell you that the need for functional capacity forms, in my opinion, is not as great as it once was. More and more doctors will not fill them out. Look, doctors are dealing with the same issues that everybody is. They've got a limited amount of time. They're under a lot of pressure. Insurance companies and the government, cuts what they get paid. They don't want to spend hours and hours filling out forms for little or no money. In fact, I've got a friend of mine I went to college with, and he is a physician here in Atlanta. He's a concierge doctor, which means that he, basically you pay him. I don't use him, but you pay him, $2,000, $5,000 a year, whatever, and you have access to him whenever you need him. But he does not fill out insurance forms. Because he said to me, I had to ask him, he said, what was happening when he was not doing it that way, he goes, I would treat my patients during the day, then I would spend 4 and 5 hours every evening filling out insurance forms for less and less money. He goes, finally, I just said, forget it, I'm not doing it anymore. So, I don't know that forms are absolutely essential. I think that, those are difficult cases because they're invisible illnesses. I've said this many times before, but what I look for to win a depression, anxiety, PTSD case are what I call indicia of severity. Indicia of severity. In fact, if you're interested, I talked about this last week, and there's a new program I'm testing out, an AI program that will pull little snippets from, live streams, which are 2 hours. And so I did one, and the one I did, I don't think it's gone live yet, is about this very topic. What I look for are indicia of severity for mental health cases. What I mean by that is that everybody who files for disability just about has a level of depression. You're not working anymore. You're not interacting with people. You've gone from being productive to sitting at home looking at the four walls. Everybody's going to be a little bit depressed. And there's a lot of depression in general. We live in a very stressful world. So to move the meter with Social Security, you've got to have evidence that's really severe. The type of things that I find work if you're alleging disability solely on mental health would be things like an inpatient hospitalization, one or more, recently, not 10 years ago, the last couple of years, where you got so out of balance that you had to be hospitalized. You lost touch with reality. You were suicidal, whatever. You had to be hospitalized. That's evidence of severity. A suicide attempt, evidence of severity. People don't, try to take their own life unless there's something really serious going on in their life, and depression or PTSD or anxiety has reached a really untenable level. Treatment from a psychiatrist, medical treatment, where the doctor keeps changing the medications because they start with one, it stops working, and they keep increasing the dosage. So essentially, you're non-responsive to medication. Treatment-resistant depression is one phrase you may hear. That's the level of impairment you've got to have. Going from, medication to medication. That you're treating with a doctor. You've got this 2, 3, 4, 5-year history of treating with a psychiatrist. You're treating with a psychologist. Everything they're trying to do, nothing is really working to control it. I would get statements from former coworkers, supervisors, people who know you, who can talk about what they have observed about what you go through. A spouse or parent or child, can help a little bit, but I think it's really better to have a former coworker. But that's kind of what you need, I think. Now if depression or mental health is your primary issue. Now, if you have something else, bad back, bad knees, heart issues, something like that, and then you've got depression, it can be at a little bit milder level, and that can help add to the equation. Or mild to moderate depression can help you win on a grid rule, because if you've got the physical limitation that limits you to sedentary or light work, the depression would interfere with focus and concentration, would not allow for transferability of skills or entry into skilled work. So it can help if you don't have a severe level, but if depression, mental health is your main issue, it's got to be at a really, really severe level. St. Louis Grand, thank you, St. Louis. You're a regular. I really appreciate the tip, $10. Thank you, much appreciated. It will go towards a sub sandwich tomorrow, probably, because I don't have anything in the house. I was looking around today, like there was nothing in my house to eat. I mean, I had like literally for dinner tonight, I had cheese and crackers. I mean, come on, it was just, but nobody went to the store, so it's probably my own fault. But I'm going to go probably by get a pub sub tomorrow. Publix makes pretty good subs. I'll probably do that. So the $10 will go to my pub sub tomorrow. So thank you, St. Louis Grand. How do I advise my clients to tell the ALJ why they can't work? Do you recommend starting with symptoms, impact of the symptoms as related to paragraph B, followed by capacity to work? And paragraph B is talking about, I think, is probably the functional issues. That's a very, very good question. I mentioned I had a client who, again, has been on here, and she may be on, hopefully she's on tonight. And we talked about this after her hearing. We're going to win. We had a difficult judge, but we're going to win. She did a really good job at the hearing. And I had provided her a list of questions that this judge typically asked. And what she told me she did was, she says, I took those questions, I put them on index cards. The question, I wrote up my answer, or typed up my answer. And I sort of had it like as almost like index cards right in front of me on a table, and I kind of divided them up into categories, about physical capacity, mental capacity, reliability, things like that. So that's an interesting way to do it. And I think I'm going to take that list of questions. I'll put it out on the website or someplace where people can see it. And that's not a bad way to do it. So I would say, there are certain questions you're always going to be asked. And so I think number one is you want to make sure you have those questions ready to be answered. Notes, you can have your own personal notes or on note cards where you can answer what you did past work-wise, just stuff like that. You're always going to be asked how long you can sit, stand, walk, crouch, crawl, stairs, ladders, things like that. If it's physical, there are certain questions you're always going to be asked. So you want to make sure you got those questions answered. I think that to answer St. Louis Grand's question, I think first of all, you want to have an elevator speech. So you can say in 2 or 3 sentences why you're not able to work, and specifically you want to talk about the symptoms that prevent you from being reliable. I would start out with, what I do is when I'm questioning my client, I kind of give a little bit of a history. I want to sort of set the stage. Just that this is a long-standing problem. My back issues are a long-standing problem. My depression is a long-standing problem. I suffered with this, as a teenager, as a young adult, and as time has gone by, it's gotten worse. I was in the military, and I dealt with, I was in active combat, and I saw people, being killed and brain matter, and it's something that, as a younger person, I was able to kind of compartmentalize it. I was busy raising a family, but as time has gone by, I'm having more and more flashbacks. So I try to give a little bit of a history. Or, my diabetes was, I was having trouble controlling it. I wasn't really having any symptoms. After 3 or 4 years of not being under control, and this is one of the cases I had this past week, I started having the complications, the retinopathy, neuropathy. So I would kind of give a brief, big picture overview of how you got to this point and how it's gotten worse over time. Then I would kind of go through the individual medical issues, starting with the one that's most important. So, for example, if it's PTSD, talk about just, the frequency and duration of symptoms, flashbacks, things like that, and what happens when you have a flashback. What happens when you have an episode of severe anxiety or depression, and how does that affect you as a practical matter in terms of doing just stuff around the house or interacting with others. If it's physical, how is it something that's every single day? Is it the same? Does it kind of depend on your activity? And what does that mean in terms of your functioning? So I would again kind of break it down by the impairment and then talk about the limitations for that impairment. Then go to the next one and then go to the next one. And I usually tell people, let's stick with maybe, 3, maybe 4 impairments at most. And you can talk about the other stuff, but again, I'll put that in the brief, but I don't usually like to go too much more than that. Then you can kind of talk about the combined effect of all those things. Then you might talk about the medication side effects and so forth. And I always tell people, and I do this in every hearing, talk about, like at my hearing today, I said to my client, you have had a career where you're making 6 figures. She had a really good career. You were interacting with people. You had a job where you had a lot of responsibility. Has this been frustrating? And this is a very successful, tough, businesswoman. And she got kind of tearful. She's like, this is the most miserable thing. I would go back to work tomorrow. I mean, I was making good money. I had interaction with interesting people. I was doing stuff that mattered. And I can't do that anymore. I'm not the same person I was. And I think that you really want to demonstrate that you're not pursuing disability because it's an easy way out or a quick retirement. That this is a last resort. You don't want to be here. You'd much rather not be here. So that's kind of the overall way I kind of break it down as far as that. But again, I just think that you just have to have your own style, but that's the way I do it to make sure it's real organized. And that's when I do a pre-hearing brief. That's kind of what I do. I kind of give a bit of a history, then I go into the different, medical impairments and what they mean, medication side effects. And then, I may go into, the claimant, if there's something in some of the forms where they talk about, just how frustrating, how difficult it's been, and kind of the testimony would kind of mirror that. So that's how I prepare my clients. Okay. Let's see here. Yes, Jeff's got a desert disability. Well, he's out in the desert. But yeah, that is a good name. I know we were talking about this. Jeffrey was telling me he was thinking about expanding to other places. And of course, attorneys, if you do video and telephone hearings, it doesn't matter. I do cases out in Phoenix. I do cases in New York. The case I had today my client was in Florida. It really doesn't matter because it's all virtual. But, some people want in-person hearings. Some lawyers like in-person hearings. Maybe Jeffrey we can talk about that when he's on. Some people think that there's an advantage. I personally don't, but if you want an in-person hearing, then that would be useful to have somebody in the locale. Jeffrey says, thank you. Yeah, okay, cool name. Yeah. Yeah, it's interesting because, for years, lawyers, we couldn't really brand ourselves. We would basically, you had to be, I'm Ginsberg Law Offices, and you hear, Smith and Jones or whatever. And then you started seeing, like, there's a guy in Atlanta, his website is like My Bald Lawyers, a bald guy. That's his nickname. There was one like the Red Hot Law Firm. I mean, there's, so you're starting to see a little more branding, which is probably not a bad thing. I don't know that it has to have a name. And of course, I always thought it was kind of ridiculous. You see these people with these, long, 5 names, you just can't, I mean, you can't even pronounce them, and it's just, McNamara, McGillicuddy, Debussy and Johansson or something. I mean, it's ridiculous to have these long names. And many of the law firms that did that now are kind of going to 2 names. So, I think it's you want to make it easier for people to find you, and certainly for a website name and so forth. But yeah, that's, I think, in fact, one of the things that's kind of coming up in the legal world is, non-attorney ownership of law firms. There has some states, I think Utah maybe, allows that. And that's kind of coming. And I think that, don't be surprised if the next, 5 or 10 years you start to see, Amazon having, a law firm, or because I know at one point I think Sears had a deal with somebody, and they had like a in the Sears stores when Sears was still in business. I think they're out of business now or pretty close to it. They had a deal with somebody who would have like little law clinics in those stores. It didn't work out very well, but I think we're going to see, and maybe not for things like disability because it's kind of very personal, but I think for certain corporate things, there will be kind of a convergence, business law firms and accounting firms, things like that. So that could change. I mean, We'll see. I don't know when that's going to happen, but I think that there's a lot of discussion about that of non-attorney ownership, because right now a non-attorney cannot own a law firm, except in certain states. And I think that's very possibly coming. Okay, and this is our Mango Bomb says the ADHD was trauma based, and it can be. Trauma can do a lot of things here. And Julio says, always tell SSA what you can't do in your worst day, not what you can do. They'll always use that against you. Here's my take. I think that when I tell people, when somebody says, well, how do I describe my day? What type should I talk about the worst possible day? I say, do it like this. If on a scale of 1 to 10, 1 is you can't get out of bed, you're just totally miserable. 10 is, you're having a great day, you feel great, you can take on the world. Don't describe a level 1 day, maybe level 3.5 or 4, not the worst day, but below average, a below average day. Because realize what they're looking at, what Social Security is looking at, is you're functioning on a day that is, this would be something you might have to do job wise for 6, 8, 10 months. Most anybody can get through a week if you had to. Gun to your head, you got to get through a week. As much pain as you're in, you could do it. But you can't do that for 6 months. So I think when you talk about a 3.5 out of 10 day, that would kind of paint a better picture of what you might be able to do over 8, 9, 10 months at a time. So that's what I would do. I would probably figure out, and again, don't say in terms of, let's say, walking and standing, I can't walk very far, I can't lift very much. No. You want to be specific. I can walk 15 or 20 feet, then I've got to stop. Or I can walk 2 city blocks and I've got to stop. I can sit in an office chair, not a recliner, because in work, you're not going to have a recliner. Office type of chair, I can sit for 15 or 20 minutes, and then the pain in my back, the radiating pain in my lower back into my legs becomes so severe, I've got to stand up and move around away from the work site, not just standing in one place, move around, take a walk around for 5 to 7 minutes, and I can sit down. I can do that 3 or 4 times, and then at that point, I've got to go lie down. For how long? I've got to lie down for 15 to 20 minutes, and take all the pressure off. Then I can go back and I can maybe do that cycle 2 or 3 times, and I'm toast for the day. Standing without support. You're in a line at the DMV. I can do it for 10 or 15 minutes, and then I've got to stop or lean on something. Walking, I can walk, on a flat surface, 10, 15 minutes, something like that. So you want to be very, very specific. You don't want to just say not very long, and you want to give the judge a sense of what you mean. Walking on a flat surface is different than walking on uneven terrain or on dirt, or climbing stairs or on a ramp. So you want to be very, very specific. And these are things that you and your attorney should discuss ahead of time, because it's going to happen in every case. So I think when you talk about this, you want to be able to really paint a clear picture of what you might be able to do, because, certain jobs, require you to be walking. If you're in let's say a warehouse position, you might have to walk, 4 or 5 hours during the course of a day. If you are in a situation where you got to climb a ladder or scaffold, that may not be possible. So really what we try to do in the hearings, we start eliminating categories of jobs, jobs where you got to stand for more than 15 or 20 minutes at a time. You eliminate, 30% of the jobs that exist in the economy. You can't sit for more than, 30 minutes. That eliminates another percentage. We keep eliminating just whole lines of jobs. That can be very, very, very helpful. Okay. Crucible. I failed to get the necessary test to meet a listing until 9 months after onset. Is there medical proof? Does the error set your onset date before the required test? Well, I would answer that in 2 ways. First is that you could certainly make an argument that if you have a listing level condition, that it did not arise out of the blue, and that it likely existed 9 months ago, that you simply got the test. Let's say, for example, it's a cardiac issue, and the test was to measure your ejection fraction, which is a test at the cardiac listing. Well, if you have a 25% ejection fraction, and you're tested in November of 2024, but you were having the same symptoms in February of 2024, you can make an argument that you were at listing level back then. Now that may not work because they're going to say, well, we didn't have the test back then. But you could certainly argue functional capacity, because even if, you realize the listings, they make them very, very hard to meet. So if you cannot convince the judge that you are at listing level 9 months prior to your test, you can say, well, now I'm at listing level, my symptoms were the same. There's evidence to that effect. So let's analyze this as a functional capacity issue, and that my functional capacity was, certainly if it was not at listing level, it was at a work preclusive level. So that's how I would argue. I would argue, A, that if you're listing level now, that you probably were before, and there's evidence to that effect, or B, we don't know what you were before, but we do know that the symptoms are pretty similar to what you have now. You're now at listing level. Therefore, we're not going to argue listing. The alternative, we're going to argue that your functional capacity has been so reduced or eroded by the symptoms you've got that you would not be a reliable employee. Robert Saul, living with PD. I'm assuming that's Parkinson's disease. Are you seeing, by the way, again, I'm assuming it's Parkinson's. I've had several clients recently with Parkinson's, and I was talking to one of my clients a couple of days ago, and he made the very interesting point, he or she, I think it was a she, I can't remember, interesting point that there seemed to be a correlation between Parkinson's disease and certain medications like Adderall in particular. And, interesting point that people who were taking Adderall or were exposed to environmental toxins, that may have triggered Parkinson's disease. I'd never really thought about that. And I called a couple of my clients with Parkinson's over the last couple of days. And, everybody seems to think, that may be part of it. Now, sometimes it can be a hereditary type of thing. But I think environmental toxins can certainly do. I'm seeing a lot more people in their 50s and 60s with Parkinson's with no family history. So, whatever that's worth, that's an interesting argument. Okay, are you seeing long lead times between notice of decision of Recon and the mailing of the letter with final decision and details? So what you're getting at, Robert, is that sometimes Social Security will make a decision. The letter itself will say, November 3rd, 2024. They mail it November, 20th or December 5th. I have seen that over the years. Not as much recently, because now, of course, you can go online and you can see that the decision's been made. So I think that I would certainly encourage everybody to sign up for an online account so you can see that a decision's been made. But there can be a gap of a couple of weeks. Now, I had one case years and years ago, and again, I think this was a one-off, where literally the decision that was dated January 13th or something of, whatever it was, 1995 or something, and then it was not mailed until April. And of course, it was after the 60-day appeal. And so I basically, filed a motion for good cause or application for good cause saying, here's the postmark. Look at the postmark on this and look at the date. And they turned it down. They said, no, we're not going to consider that good cause. I'm like, what? But there's no appeal to it. We had to start over. So, that was that one situation. But I would say, but that was, again, very much an unusual situation and really, just unfair. But that's what they did, again, 25 years ago. I would say if you have an online account and you see a decision's been made, if you don't get something in the mail, you get on the phone and call them and say, fax it to me, email it to me, whatever. I need to know. And worst comes to worse. I've done this a few times. I'll know from a phone call that the decision's been made. I'm running out of time. It's the 60 days is coming in. I will actually literally write a letter. In my case, I would take the Recon form, I would fill it out, and I would fax it in, to Social Security to prove that I got it in within the 60 days. If you don't want to do that, you could certainly write a letter. And because they've got to take it, even if it's not in their form, a letter, dear Social Security, it's my understanding that my initial application has been denied after much effort. I've not been able to get a copy of the unfavorable decision. However, assuming that it has been issued, please allow this letter to serve as my appeal. Please advise me what additional paperwork I need to provide you. And if you can get the case number, because now they've, to make it even more confusing, they've gone away from using Social Security numbers. They use case numbers, I think it's called the case number, claim number, something like that, which is like a 7 or 8 digit number. That way it gets to the right place. But I think that if you can prove that you got it to them, if you have to physically take it down to the Social Security office, do that, get a stamp. But a fax receipt, probably is going to be enough as well. And you just have to do what you got to do. But yes, I have seen sometimes a gap of a week or two, but really not more than that. Let's hope Trump cuts so I think what you're talking about, there's been some talk about cutting taxes on Social Security benefits. Right now, depending on your household income, if you receive Social Security, disability, or retirement, you could be taxed on that money. And, one of the things that Mr. Trump has talked about is cutting those taxes. Whether that will happen, and I will tell you, one of the things that there's been a lot of criticism for is that some of the tax proposals that Mr. Trump has come up with would create a real problem with the budget, and particularly with Social Security, in that the trust fund, which is kind of an IOU, it's not really money there, it's an IOU, is projected to run out of money in 2035 or 36, which is like 10 years from now, and that some of these proposals would make that happen a lot faster. So I don't know that the American public has the appetite for that, so we'll have to see what happens there. Sparkle, I received my Social Security disability back pay and paid off debt to increase my credit score in order to buy a home. Unable to buy a home due to my yearly income. Is beneficial to buy with my husband if we're separated. All right, that's a question probably a little bit beyond what I do, and I did do bankruptcy work for a long time. And I know my brother-in-law is a mortgage broker, so I know that the underwriting requirements for mortgages are a lot different. So you have a high credit score, but you don't have enough income, and I'm not sure. I don't even count Social Security income. I don't even know. So I would say this: if you can get somebody to co-sign on your mortgage, that benefits you. Now, I would tell you, when I did bankruptcy work, I would tell my clients never co-sign for anybody, because if they don't pay, you're on the hook. Social Security, Sparkle, is not something that a civil creditor can go after. So if you should default on that mortgage, and of course mortgages typically they foreclose and that's it, but it's still an obligation. If you should default on it, then your ex-husband or your separated husband would be on the hook. So if I was talking to him, if he called me and said, should I, co-sign for my estranged spouse because, she doesn't have enough income to, qualify for a mortgage, I would tell him, you out of your mind, don't do it. But, if I'm talking to you and you can find somebody to do it, then more power to you. Okay. Adam, XLG. Got an examination in a week. I have the CT image for cervical stenosis, no MRI yet, or EMG, also hiatal hernia. What's my chance of getting approved? Thanks for everything. What does the CT say? How bad is the stenosis? What are the symptoms? What are the symptoms of the hiatal hernia? How old are you? Those are all the questions I would be asking. I mean, I don't know. I mean, it's like saying I have carpal tunnel. Am I disabled? Well, is it mild carpal tunnel? Is it severe carpal tunnel? I have depression. Is it mild? Am I suicidal? It just depends on the degree, and more specifically, what are the specific impairments? Cervical stenosis, that could be something where you have numbness radiating to both arms, you can't turn your head from side to side, and you have terrible migraine headaches because of the pain. That might be disabling, especially if you're over 50 or 55, then you have the grid rules could come into play. You're 35 years old and you have mild stenosis, probably not going to win. So it just really depends on the facts. Breach 66. Hello again from Pennsylvania. Hello, Breach. I had my hearing last Thursday. I had a vocational expert, no medical witness to judge. I'm not an expert in any questions. I'm 57. Asked me only 3 questions. That's probably a good sign. I think that if you had no questions of the VE, unless the evidence is either really, really weak or really, really strong. So assuming that the evidence is decent, you got 3 questions, that's usually a pretty good sign that you are going to win. So that's my take on that. All right, Jen, my paralegal, Jen from Lincoln, Nebraska, is checking in. Hello, Jen. What's the wrench about? You got a wrench on your YouTube avatar. Okay. I guess because Jen's always fixing the mistakes I make. Maybe that's what it's for. Muley. It's disappointing on fast track, but it was 100% PNT. It's been almost a year. No answers. So Muley's talking about is if you're 100% permanent and total by the VA, your case should be expedited and put to the front of the line in a Social Security hearing. You're not, or a Social Security case, not just a hearing, but administrative level as well. VA determinations are not binding on Social Security, but they are made note of, and certainly it's relevant. But most important thing is you get to the front of the line. If you're in Florida or Texas, you're going to be waiting a long time because those states are way, way behind. So imagine if you were not getting to the front of the line, how long it's going to take. I think that you want to make sure that Social Security has evidence of your 100% rating. If they've not, you want to send it into the adjudicator and say, my case should be expedited. It actually says on the case file, expedited hearing or expedited case because of 100% VA. And it's possible they just don't know. Nobody made note of that. That could be the issue. Or it could just be the state agency is way, way behind. Okay, like Jen's fan club is here tonight. Okay, good. Hello, Jen, says like it is. I was sent to an internist by Social Security. They took my blood pressure. It was high. But the medical assistant said blood pressure monitor not giving adequate readings. That seems wrong to me. Yeah, again, and Dr. Foster will be able to talk more about this next week. My experience has been that the internal medicine, the physical medicine doctors that Social Security sends you to are just not all that impressive. These are doctors that work in clinics that do reviews for insurance companies. Many times they are not, the best. They don't have private practices. They get all their money from insurance companies. So it seems to be their goal is to find there's nothing wrong with you. So that's certainly the situation. And if the medical assistant said the blood pressure monitor isn't working, how hard? You can go buy a blood pressure monitor at the drugstore for $20. So how hard is that? So what I would tell you is write down all the things you can remember about this evaluation. The fact that the assistant told you your blood pressure monitor was not right. Maybe go to drugstore, get your blood pressure taken and see what it is. And so what it is now. You had an evaluation last week. If the blood pressure in that report, and you can get a copy of that report, it'll be part of your file, is a lot different than what you got at the drugstore, you can say to the judge, look, that didn't make sense to me. I went to the drugstore, my blood pressure was, 180 over 130, way, way too high. But at the doctor's office, they said it was 120 over 70. Doesn't make any sense. And this person told me, and I would use that to argue as an attorney. I would say this consultative evaluation should be given very little weight because, the guy can't even, calibrate his equipment. So that's how I would deal with that. St. Louis Grand, how do you advise your comments, they can be claimants, clients, to preemptively address being on unemployment insurance during a period where they're applying for SSDI and SSI? I think what you're getting at is when you apply for unemployment, you are saying, I'm ready, willing, and able to work. You basically are certifying that you're able to go do a job. I don't look at it like that. I think that what you're saying to the unemployment agency is, I'm ready, willing, and able to try to work. You are not a doctor. You have not tried to work yet. All you're saying is, I'm willing to try to work. And so I'm collecting unemployment with the idea that I would like to go back to work. And if I could find something I could do, I would do so. However, I'm not a doctor. The medical evidence, I believe, supports my argument that I cannot go back to work. So I don't think there's an inconsistency there. You don't know for certain that you can go back to work. So you're just saying, I'd be willing to try. So that's how I deal with it. I have not had, there was a brief period of time, probably 15 plus years ago, where judges were asking people, did you apply for unemployment? They were basically finding them, they were saying, we're going to change the onset date because you were saying you were ready, willing, and able to work. That's not consistent with being disabled. I'm guessing some smart lawyer appealed it and said, saying that you're willing to try to work is not the same as that you have capacity for work. You're not a doctor. You don't know. And, in the law world, legal business, we have something that is very common called making arguments in the alternative, meaning I can argue, I think my client meets a listing, but if they don't, I think they meet a grid rule. If they don't meet a grid rule, I think they are disabled under a functional capacity argument. You can argue things, 3 different levels. You can argue if it's not one, it could be something else. But at the end of the day, I'm still disabled. Just the theory of disability is a little bit different. So, saying I'm able to try to work is not the same as having the capacity to work. So that's how I would deal with that if it should come up. And again, I think I would use it to my favor by saying, look, Judge, not only was I was getting unemployment, I needed the money. I think judges understand that, appreciate that. But yeah, I needed the money, so that was that was part of it. But more importantly, I want to try to work. I don't want to not be working. I don't want to be, sitting at home, looking at the 4 walls. I'm willing to try to do anything, even if I couldn't do it. And realize Social Security's got this whole thing called unsuccessful work attempts. So they recognize that, people who try to work will not always be successful. So that's how St. Louis, I would deal with that. Okay. Hello, Jen. Where can I write a review? Okay, very good. I would have babbled what I thought the judge wanted to hear and should effectively advise the attorney. Thank you. Appreciate that. Well, I just put that on the bottom here. You can go to, just go to bit.ly/Jonathan-review-5, or you can go, I've got a website called jonathanginsberg.com, just my name, and you'll see a place that says, leave me a review. So that's where I would do it. But I really appreciate that. Those reviews, I usually get folks that are nice enough to do it after these live streams. It really helps. I mean, it makes a big difference as far as my placement with the search engines. And I think a lot of people rely on reviews, to decide about lawyers. And again, I try to be very transparent about what I know, share what I know. And so, I think it's kind of I appreciate the fact that people are taking the time to write reviews because, again, it really does help. But that's how you do it. I'll leave that crawl there for a little bit. All right, Garrett is saying hello to Jen. Okay, SA is another regular here. With foraminal stenosis, bulging disc, S1, nerve impingement, arthritis, lumbar back, what pain levels, what percentage of time, and what type of limitations or movement are necessary. I think that, nerve impingement is a big deal because it says that would explain, and the stenosis, that would explain the radiating pain. I would say that, in terms big picture, if you're off task, that's the phrase they use in the disability world, more than 15, some VEs say 10%, some say 15%, we'll use 15%. More than 15% of the workday, which is going to be, roughly an hour in a workday that you're not able to work, that would be excessive. I would tell you if you are going to testify that you're having to take a break to lie in a recliner for 20 to 30 minutes, 2 or 3 times a day, that would be disabling if the judge believed it. Okay, so, or if you are taking pain medications that cause you to go to sleep and you fall asleep, once or twice a day after taking pain medications, that would be it. So I think in terms of being off task, an hour off task is going to be excessive. I think as far as your physical limitations, things that seem to move the meter, at least in my cases, if you have trouble getting dressed, you have trouble getting your shoes on because you can't bend over, you have trouble getting pants on, you have trouble getting, a shirt over your head because you raise your arm, you can't raise your arms over, a certain level. I've had women say they can't get their bra on, they can't wash their hair. Things like that. They need help getting to the shower. They have to have a shower chair. So I think the way you describe that, but I think, getting dressed, not being able to do household tasks. I can't cook because if I'm in front of a stove, I have to sit down. I can't stand and chop vegetables. I can't use a fry pan. things like that. So you want to really just show that your capacity to do any kind of a exertional move, standing, leaning over, bending, stooping, walking, standing, all that kind of stuff. If it's all, 10, 15 minutes, you got to take a break, that's not really consistent with work. So I would say that in terms of your activities, 10, 15 minutes, I got to take a break. That's going to kind of be work prohibitive. And if you're taking unscheduled breaks to rest, take the pressure off for, 30 minutes at a time, twice a day, 3 times a day, that would be probably enough. Again, assuming the judge accepted that. Kelly had to leave last week's live and watch the replay. Belated thanks for giving your collaborative with Dr. Dave Foster. He's delightfully quirky, knowledgeable, and helpful in equal measure. So he does go by. I'm gonna have to ask him beforehand. Do you prefer Dave or John? I mean, he when I emailed him, I said, somebody this past week said, that they've looked at your YouTube channel, which I have as well, and that would be interesting to have you on. I said, would you come on? And he's like, absolutely, love to do it. And he and I had corresponded before. But he sounded John Foster. So, I just called him Dr. Foster because I was sort of brought up a doctor as, a doctor. He calls me Mr. Ginsberg. We'll have to get past that. But anyway, he's got the red bow tie if you haven't seen his YouTube channel. But he is very, very, very knowledgeable about consultative evaluations. And he's done these for a long time. And I think he'll be able to give us some real insight. But yeah, it'll be next week, again, assuming nothing comes up for him or me, but it'll be on next week. He'll be on and we'll ask him questions. I'll have a bunch of questions prepared about consultative evaluations and really, what you need to do as a claimant to help the doctor write the best report. And what do you do if you think the doctor is hostile? And, I think I've told y'all, they will look at you in the parking lot. They'll look at you in the waiting room, just to be aware of that kind of stuff. And, what Social Security communicates to him. That would be kind of interesting to know. So we'll get all those questions hopefully answered by Dr. Foster next week. Duarno said, I had my hearing this Tuesday. The ALJ submitted the requirements for disability. Does this guarantee a win? Sounds good. I mean, I think, if the judge says you meet the requirements, then that sounds pretty good. Is there anything called a guarantee in the Social Security world? No guarantees. It sounds pretty good. And, hopefully if you had an attorney, the attorney can confirm that. But if the judge announced in the record that you meet the requirements, then I think that's a pretty good sign. But guarantee, we don't work in guarantees, unfortunately, Duarno. It just doesn't work that way. All right, rock driller. So that's a physical job right there. You're a rock driller. So that's, grid rules right away, I think. Had my medical consulted with a Social Security doctor on October 5th. What's the average time for approval decline? Haven't heard anything from SSA or the lawyers. Realize that the consultative evaluation is part of the puzzle. So, after you've had that, it goes into the overall exhibit file. The adjudicator is collecting medical evidence. And once the file is sort of at a stopping point of completeness, the adjudicator will send it to one of their doctors in-house to review it. That person will look at the consultative report as well as the medical report from your treating doctors and make a recommendation. So again, the average time for initial applications overall in the country, 8 to 12 months. Texas or Florida, add 5 or 6 months to it. Georgia even is getting pretty bad. But there's no average time after your consultative to get a decision. It's just part of the puzzle. Consider overpayments, free interest loans, keep sending. Well, yeah, but if you at some point, if you get an overpayment, you have to pay it back or bankrupt on it. Yeah, theoretically, you could put that money into a CD and earn interest on it. Is it worth the hassle? Probably not. Shouldn't the doctors that send you have good operating blood pressure monitors? Exactly. I totally agree. DL, I think that, if they can't, get a blood pressure monitor working, I mean, what kind of medical practice is it? I mean, that does not really, imagine going to a doctor and the doctor says, well, my equipment doesn't work. My stethoscope doesn't work. My blood pressure monitor doesn't work. You can walk right out. But these are the doctors they use. Stacy Paulson, how much does it cost to hire an attorney? No upfront cost. We do these cases on a contingency. Contingency meaning past due benefits. If you're, because it takes, a year or 2 years, that you have an onset date, and the first 5 months after onset, you're not paid. And then after that, your benefits accrue. So let's say that your benefits are $2,000 a month. You applied a year ago, let's say on October 12th of 2023, and your onset date was October 12th of 2023, make it simple. You would not get paid for the rest of November. You don't get paid for December, January, February, March, April. You start getting paid in May of 24, after the 5-month waiting period, 5 full month waiting period. And if you're approved in November, so you're looking at maybe 6 months of past due benefits. If it's $2,000 a month, that's going to be $12,000. They would pay me 25% of that, $4,000 as a fee. It is capped. Right now, our fee is capped at $7,200. As of November 30th, unless it changes, it's going to go up to $9,200. So, but that's how we're paid. But it's never going to be a flat, like in a personal injury case, you pay a third or 40%, no cap. Social Security caps it, but it's 25%, but there's no upfront cost. So, the positive is you don't have to come out of pocket any. The negative is that attorneys that do this, myself included, we have to be selective because we're not going to get paid if we don't win. So, it's going to be hard for me to take a case where, there's not a great chance of winning. Again, the person who called me and said, I want to try to prove I was disabled in 2003, not likely to win, a lot of work. And if I win, I only get paid, I'm going to get paid $7,200. And it's not even that because they charge a user fee. So it ends up being $7,083 and specifically. They discourage attorneys from taking the really tough cases because they cap our fee and set our fee. But there's no upfront cost is the answer. Okay, waiting on a non-medical decision. I found a medical requirements for SSI. The actual wording was, we determine the conditions of severe results in the finding of disability. Okay, so what you're asking me is, what are the non-medical requirements, I suspect? Hold that thought. All right, SSI, as you know, is a means-tested program. And it's different from SSDI, which is based on your earnings record and your payment into the system. SSI is not based on having an earnings record. So it's basically a means-tested program. You're limited to, I think it's $2,000 of assets, not including a house or a car. Household income will be deemed to you mostly. So if you have a spouse who's working, it'll be deemed to you. So in every SSI case, they do, I think it's called an EOD interview. We used to call it a income and resource interview, where they ask you questions and do a little digging into your income and your resources. If they show that your income and resources are not exceeding the SSI limits, they pay you. That process can take a few months, but that's what's going on in an SSI case. You've met the medical requirements, which is good. Now you have to meet the non-medical requirements. And in SSDI cases, by the way, what they will look at is not income and resource, because it doesn't matter in SSDI. They will look to see is, have you had any earnings to show that you're working at SGA level or more after onset? And if you do, they'll want to know what that's all about. Okay, let me change the crawl. Garrett's going to get mad at me. Let me change the crawl here. Okay. Let's see here. Julie, 57 and a half. That's good right there. I can tell you right there. New York City teacher for 20 years. Obviously that's, teachers and nurses, that's kind of a calling. I think that, I think judges will give nurses and teachers a little more of the benefit of the doubt, because you don't go into those professions unless you have a desire to really help people. And I think that really comes through in Social Security. Injured at work a year ago, red flag, I'll tell you in a second. 2 bad knees, torn meniscus, 1 failed surgery, lymphedema, arthritis, multiple symptomatic herniated disc, depression, anxiety. Okay. Those conditions, again, we haven't really talked about the, what they mean in terms of your functioning, but those are significant conditions. The real red flag is the work. because if you have an active workers' compensation case, that's going to be a problem. Because if you're getting workers' comp benefits, that offsets Social Security, there'll be no past due benefits. So an attorney like me could not take that case. Because if you're getting ongoing workers' comp benefits, there's no past due benefits for the attorney to get paid, and you won't see any money until you settle your case. So depending on whether you settle the case, what's going on with that would be, it would go from either a case that looks like it's likely one that most attorneys would say, this is a really good case, we can win it, to I can't take it because there's no way I can get paid. So that is that's the answer there. But we'll talk about that. I think you're the one who said you submitted something, so we'll look at that in more detail, maybe the next day or so tomorrow. Okay, what is the dollar range for payment? It just depends on your earnings record. I mean, I've seen it as high as $3,200. Most people I'm seeing are in the, say $1,800 to $2,500 range for SSDI. SSI is capped at I don't know, like $1,100 or $900. Not a whole lot of money, but it's around $1,000. SSDI is typically, like I said, in the $2,000 to $3,000 range. One of my daughter's twin sons is autistic. He's been in the hospital 3 times from traumatic. She's a single parent making $80 with high mortgage and other responsibility. He's been denied twice for SSI. Why is that? Did they deny him because of medical reasons, or did they deny him because of household income? I think the question would be, why did they deny him? And if it's because of medical reasons, for whatever reason, she was not able to prove that medically he's disabled. Now, at the state agency level, they're kind of looking for, let's call it magic words. You get in front of the judge and all that, I think you're going to stand a much better chance. But I think we need to know what's going on as far as why they turned him down. Julie is in terrible pain. Epidurals, what kind of, again, I think, excuse me, Julie, I think pretty good based on that. Based on what you're saying to me, that would be a case most likely, I would take pending discussion of the workers' comp and whether you're still getting workers' comp. Stony Tony's Dabs and Drama Den. Again, there's probably a story there. Okay. In the midst of applying, and have a letter from my therapist that your mental and physical disability limit from being substantial, primary care is a letter. That will help. Realize that simply having a letter from a doctor saying you're disabled is helpful, but you need to have underlying medical records as well. And if it's something that is physical, there needs to be some objective testing. If it's from a therapist, mental health, there needs to be some evidence of ongoing treatment where that person's opinion means something. Just having your family doctor decide that you're disabled, that really, it'd be better to come from a specialist, quite frankly. But just a letter alone, it won't probably be enough. But it can help. It can certainly help. And some judges will give that more weight than others. But most judges are going to say, I want to see more than just a letter. Christina is a regular, and we enjoy seeing Christina here. Thank you very much for stopping by. Any chance to give SSI back after I down payment on my overpayment? Kevin, I'm not sure what you're asking me. I don't understand that. I think this is the one. I think you'll need more than just letters. I think you need to have underlying medical records. Is my take. Oh, great. Okay. Sandy said, just thank you. I got my approval at initial. Excellent. Between me and Joy, not sure who Joy is. Maybe another attorney, Walter, not, I'm guessing, Dr. Foster. Okay, that's why we do this. I can't speak for Walter or Joy or anybody else, but part of the reason that we go on is to give people the tools they can use to get approved. And enough people are going to hire me because their cases are maybe not as clear cut, or they don't want to deal with the hassle. And that if somebody can win, on their own, amen. More power to you. Leave me a nice review, and leave Joy and Walter and Dr. Foster nice reviews as well. Okay, I think we've already talked about that. Yeah, Foster, Dr. Foster. Dr. Foster, if you're listening to this, I apologize. I don't know why. Sometimes you just draw a blank. I don't know, senior moment. For some reason, I like when I think of you, I think of him. I think I see his picture with the red bow tie, and I always think of J. Dave. I don't know why Foster was just I was having trouble. Had a mind blank there. All right, Christina says, don't forget to like, share, comment, subscribe, please. Thank you. Much appreciated. Yeah, that'll be cool. Yeah, we'll be. I'm looking forward to that. We'll be looking forward to that. Okay, so SSI, Deb's always here with the facts and figures. For 2024 is $943. That's the most you can get for SSI. After offsets, it could be $600, $500, $300. Yes, please leave me a 5-star review. That is really much appreciated. I'll put that crawl down here. I got this fancy program. I can put a crawl. So if you're going to leave me a review, that is how you do it. Right there. Okay. Okay, Garrett tells us here as well. Okay. Yes. Congratulations. I agree. That's great news. That is great news. Derek is 36, been fighting workers' comp for 11 years, 2 back surgeries, ankle surgery, fusion, plethora, no approval. Okay, let's kind of break this down. I think a couple issues are going to pop up. Number one is your age. 36 is very young to get disability, no matter what the issue is. It's very, very hard to win at 36. I'm not just telling you that's just a fact. That's going to be very hard. I think a second problem is workers' comp offsets any Social Security you might get. So it's going to be hard to get an attorney because if you're getting ongoing comp benefits or there's going to be a settlement, that could be a problem. I think possibly the biggest issue is you're probably not insured anymore. When you stop working, your insurance runs out about 5 years after you stop working. If you have not worked for 11 years, then I'm guessing that your insurance probably ran out in 2018 or 2019. That means the medical evidence has to prove you were at a disabled level, in 2018, 2019, you might have been 29 or 30 or 31. Really, really hard to win that young. Not impossible, but very, very hard. So a lot of red flags in your situation. That's what would be the biggest concern. But the workers' comp would be the big one, I think. 943. Yeah, I mean, I think if assuming you don't have any problems with the SSI, the SSDI income and resources don't matter. But as far as SSI, if you don't have any problems, you won medically, and you don't have any assets, then that would be shouldn't be a problem. All right, Derek again is the young gentleman attempted to go back to work 4 times. Have not worked since 2000. Okay, that helps. Again, I would get your My Social Security statement, ssa.gov/my account. You walk with a cane. It's still going to be a problem because of your age. I'm not going to lie to you. Being 36 is going to be a real problem. You do have some significant issues. I would confirm that A, you're insured. You have enough credits. Go to get your My Social Security statement from ssa.gov/my account. See if you have enough credits. And because if you went back to work 4 times, but you only did a short period of time, you may not have gotten all 4 credits for the year. So I still wonder if you're insured. And then again, your age is the big factor. Yeah, it may be hard to find somebody. That's going to be the issue. That's going to be the issue. I've won 14 or 15 gigs, went to court. Okay. Vincent says, hello, Vincent's one of my clients. Hello, Vincent. Aaron, you're welcome, Aaron. I appreciate that. Yeah, SSDI, Deb is correct. SSDI amount is based on your work history. All right, Derek has these other things. No, that's no problem. Derek, I appreciate the question. Again, you've got a lot of medical issues. If you are 56, no workers' comp, sounds like you got a pretty good case. But you're 36 and you got workers' comp, and that's just going to make it really, really hard. That's going to be the big issue. T-Lux, hello, T-Lux. Meathead. If you feel you had a bad adjudicator, can you ask for another one? Calls department number, says I don't answer when she calls. You can't really ask for another one. You could reach out to the supervisor of the state agency office and basically report that you feel like you're not getting good service. You could ask your congressperson or senator, U.S. congressman, U.S. senator, to write a letter to the state agency saying that the adjudicator is not being responsive. But that's about, you can't, but you don't have the right to ask for a new adjudicator. Edgar, good evening, Edgar. How are you doing? If a severely depressed person is in the hospital, that may legally prevent them from buying firearms for suicide. I don't know. That's a good question. Possibly might. I know that when you buy a firearm, you have to fill out the pre-check, or what do they call it, the form, with the appropriate federal agency. And I think one of the questions they ask you, have you been, have you been, I know they ask about mental health issues. So yeah, it might prevent you from buying a firearm. Probably not a bad thing. A person who's suicidal probably shouldn't have a firearm. So I think that's probably not a bad thing, but it very well could. Had plant-based hot dogs. How were they? My wife is a pescatarian. She does not eat meat or chicken. She eats fish, but she follows a fairly healthy, almost a vegetarian diet. I don't eat a lot of meat. I'll eat chicken, rarely beef. I eat a lot of fish myself, but I'm certainly not, that I don't eat as healthy as she does. But she says that these plant-based hot dogs are pretty good. I've had a couple. I'm not a hot dog person in general, but if I'm eating a hot dog, I'm eating a hot dog, not a plant-based hot dog. But I think certainly there's an argument to be made that you are what you eat, and you should eat healthy. And I find that when I eat real high carbs or eat sugar, you see me on the live stream, I'm yawning more. Like I said, cheese and crackers. There was nothing in the house. I had cheese and crackers, and I was about to have a couple pieces of leftover Halloween candy. I'm like, nope. If I do that, I know what's going to happen. I'm going to be falling asleep because my blood sugar, the insulin rises. Your blood sugar rises, insulin drops off, and boom, you're yawning and falling asleep. So, as much as I wanted the Halloween candy, and you know what? I will tell you also, just my opinion, the candy that you get for Halloween, it's just not very good quality. My wife's first cousin, who a really really good guy, he owned a candy store at one point, a chocolate store. I know I'm getting off topic here, but he was saying, like, the stuff you get in the store, it's just garbage. He goes, the real chocolate is much better. And so I sort of do this, like we have a farmer's market not too far from here, and they sell like Russian, and they sell Eastern European and British and French, all these different chocolates. I always get chocolates from all over the world, and I'll freeze them. I like it cold. So I'll take a bite, at lunch or something. And, there's different, I typically like the American, I like the Ghirardelli, 72% or 80%. But, the stuff you get like, Hershey bars, I think there's a lot of filler in it. So again, not that means anything, but the point is that if you're going to eat stuff that's not good for you, at least it should be good quality, is what I would say. Okay, enough about my eating habits. Nobody really cares, right? Victoria says, hello, Victoria. Yeah, that's right. I look at it this way, St. Louis, is there are judges that you go in front of that have a 35% approval rate. I got a favorable decision from one of them today. Came out today. This judge has a very low approval rate, one of the lowest approval rates in Atlanta. Not a bad guy. He's very pleasant. But you know what? He still approves 35% of cases. So why shouldn't mine be one of them? And my attitude is, I'm going to make my case, make my argument. Now, there are a couple of judges in Atlanta that are not fair. They're mean-spirited, and they turn people down arbitrarily. Not much you can do about that. That just is what it is. But most of the ones that I know that are low approval, they just have a different mindset as to what it means to be disabled. The obvious question is, why are they judges? And don't they realize that their percentage is significantly lower than everybody else's? I can't answer that. But, if they're reasonable people and, they're willing to listen to good evidence and you have a good case, there's no reason why you shouldn't win. But you go in with the idea, I'm going to win. You don't go with the idea you're going to lose. I always believe you have to know what you're trying to prove. And, what I a lot of times will do when I've got a low approval judge is I will look to see whether we want to change the onset date or go for a closed period. And A, if the medical supports it, but B, because you look like you're giving something up. So you say to the judge, look, I'll give this up, but go ahead and approve it. And sometimes, it's the power thing that they feel like, okay, I got something back from you, so I'm going to go ahead and approve it. Maybe the case. Can it make a decision in a cessation case? I think it's possible. I've never seen it happen, but I don't do a lot of cessation cases, so I'm not the one to ask about that. But yeah, if the evidence is clear that you should not have been terminated, it's like an on the record for a regular case. Yeah, they can do it on the record. Which is why I do a brief in all my cases, because there have been enough cases, I can think of 2 in the last month where we actually went to the hearing. Hearing lasted like 2 minutes, 5 minutes, because everything needed to be said in the brief, and the judge is like, okay, I can live with that. Let's go to approve. And, sometimes the briefs, I don't get them in as fast as I'd like because I want to, need information from my client. And so I'm really trying to get those briefs in, a week or two ahead of time. Maybe I've had a few like that too, where I'll get a phone call, judge saw your brief, willing to go with it. No need for a hearing. Great. So that's a good thing too. All right, Kim. Received a message, says awaiting non-medical review. Yeah, that's probably a good thing. They're not going to do a non-medical review to see if you're working, if you were not going to be found disabled. So I think that's a pretty good sign. Pat Vega. Can a man collect Social Security disability at age 60 or collect survivor's benefits from a lost spouse? I don't think so. I think that you're limited. You can't double dip on all these things. I believe it's going to be, you'll get the higher of the two, but I don't think you can collect both. But you know what? I don't deal with survivor's benefits, so that's my thought. I would definitely check that out. I don't think so. What if the mental health condition is due to combat related? Yeah, I see that a good bit. And I think that people who have been in combat, who've served our country, which we all appreciate, that can generate PTSD. And I think that it's very reasonable to think that would. And, a lot of those folks are 100% VA disabled. And yeah, I think that would be, when I'm doing a PTSD case, I always ask about the trauma. And, if it's something that has been a trauma over months at a time, I was in combat, I was in theater for 12 months, 18 months, and every day I'm going out and people are shooting at me. That's the sort of thing where your adrenaline is just churning 24/7. It's going to have an effect. It doesn't mean a one-time trauma. I had a case one time where my client was at in an office, and the boss was going through a divorce, and the estranged husband, I think, walks in the office, blows the guy away in front of my client, and brain matter scattered and blood is all over her. It was a woman, I think it was my client. And, that was a one-time trauma, and she developed PTSD, understandably so. But judges kind of want to know about the trauma. They do. And I think that, being in theater, being in combat, I think that is a perfectly reasonable reason one would have trauma in the flashbacks and so forth. And, I think that can make it for a pretty good case. All right, Sharon is here. This is the person that I was telling you about before, who gave me the idea came up with the idea of using a storyboard. And what we did was, Sharon had a case. We had a case today with a judge who was, not a high approval judge. And so, I reached out to a colleague of mine who is in the same city as that judge. And this colleague, just to see what the person thought, and the colleague had a list of questions that the judge asked. And this is kind of a useful list because it really applies to a lot of judges. And so I sent it to Sharon, my client, who just left this comment. And so what she did was she created a storyboard. She cut out the questions, she answered them, and she had it all on index cards right in front of her and kind of divided up into categories. So when the judge would ask a question, she knew the next 2 or 3 questions coming, and she'd already thought about how to answer those questions. And we went over it. And during our pre-hearing call, we went over that. We went through the questions, and we kind of tightened up her answers on those to be more what Social Security wanted. And lo and behold, it worked. And so, she said that having she calls it a storyboard, having that in front of her gave her a lot of comfort in being able to make sure that we got through everything. So we're going to take that idea. I think it's a really good idea, and I'll probably call you, Sharon, to go over it a little bit more and kind of, make that a little more of a something that people, just a model that people can follow. And we'll get the questions out there because I think it's a really good idea to help make people more comfortable. Because look, it's hard sometimes. You get nervous, and to answer questions just without having something in front of you. This is a good way to do it. So thank you, Sharon, for tuning in, and thanks for the really good idea. Sparkle. Oh, Deb's talking to Sparkle. Yeah, she was asking about why her I guess grandchildren were being denied. It could be that too much resources. Okay. I think Pat Vega. Yeah, we talked about that before. Okay, that's interesting. So Sharon used, I guess, ChatGPT was a great source to have draft answers as well, the live stream videos. Okay, that, I never thought about the AI. We didn't talk about that, but that's interesting. That I think what Sharon did was the question, about how long can you walk? Go into ChatGPT and ask, what is the best way to answer a question about your capacity to walk in a Social Security disability hearing? That's certainly an interesting way to do it. Never thought about that. Now, again, that's something your lawyer should be able to tell you, but, why not tap into the hive mind and chat GPT? Interestingly, speaking of AI, I have a new client who was an executive and dealt with AI at a very high level. We were talking about that a little bit today. And, he was telling me about some amazing things that AI can do. I've not seen it really yet. There's a lot of talk in the legal world that AI is going to replace lawyers and you can, get a lot of stuff done. But everybody seems to agree that a human's got to look at it. So, I know some lawyer groups that I belong to, they talk a lot about using AI to come up with job descriptions for new hires, using AI to draft certain contracts or to, answer certain questions, and maybe even to come up with questions. Maybe I'll try to come up with questions for video. I still think that, that's better than AI, so, but, down the road, who knows? Who knows? I think that, AI is tapping into, millions and millions of things on the internet. Now, of course, everything on the internet is not true. And, as you probably may have heard, there was a couple of lawyers got themselves in real trouble. They submitted briefs to federal court judges and let AI write it, and the AI engine made up citations. And when you're writing a brief or a motion in court, any court for that matter, you may reference a case. So let's say, you're writing an argument about, what's appropriate consideration for a contract. Consideration means, what somebody's giving up and the value being exchanged. And so let's say there's a case that said that consideration, both sides have to give up something of value. You can't have a valid contract if one party doesn't give anything else up. I think there was a case, maybe Hadley versus Baxendale or something like that. I think that was that case from law school. I could be wrong, but something like that. Talked about consideration. So the point is that the AI engine came up with some, Smith versus Jones and a fake citation. And the judge checked it like there is no such case. And the lawyer was lazy. And so, some federal judges now require you to submit a statement with your briefs, with your motions, your pleadings, that if you used AI, that you have personally checked the citations and you're not relying on an AI engine to do it. So, don't assume because it's done from AI that it's right. I used, there's and again, I'll get off this topic in a second, but I used an AI engine, and I got to be careful because of privacy issues. So there are a couple of vendors that offer the privacy, controls that I think are appropriate, that you can dump a PDF in of all the claimants' records, and it'll come back with a kind of a summary of the medical. Well, what it came back with was not very good. It was not usable for me. It had some stuff in there that was valuable, but it emphasized the wrong thing. So I'm not convinced that AI is the be-all and end-all yet. And again, there's still a lot of wrong stuff out on the internet. But yeah, I don't know why, you couldn't use AI as a starting point. I think obviously Sharon did. What do I ask at SS? What do I ask most people are not aware of? I'm not sure. Let me just see. Okay, so Pat was asking about can collect Social Security disability and also survivor's benefits from lost spouse at the same time. And so Deb says yes. Now again, I'm only, that's what Deb says. I'm not going to, I don't know. And who do I ask? This might be a situation where you ask Greg, the disability Yoda, and Greg. Why am I having such trouble with last names? I don't know why. This is crazy here. But Greg Brinkley. Okay. I'm having trouble. I couldn't remember Dr. Foster's last name, and I couldn't remember Greg's last name. I just call him Greg, so that's probably why. But Greg Brinkley might be a person to ask. Greg at gregbrinkley.org. And he might be able to answer that question because he used to work for Social Security. So that would be a person I would call or reach out to. Greg at gregbrinkley.org. Derek, my pleasure. I hope I was able to give you at least some things to think about. Sure, Pat. I'm happy to try to help. And again, Greg would be a person to talk to. If you had to get a fusion in LMA, not sure what an LMA is, from C3 to 7, would you do it? I'm not sure what an LMA is. I'm guessing it's a cage or some instrumentation. Would I do it? I guess it depends on how uncomfortable I was. I mean, if you have really unstable vertebra in your neck, and you're in excruciating pain, you're always hurting yourself, and a fusion might give you some relief, I'd certainly consider it. I mean, my wife does workers' comp, as you all may know, and we talked about, we talk about back surgery sometimes, just, we'll talk about cases every once in a while. And she made an interesting point. She said, it's with cervical surgeries, her experience is that many times they work out better than lumbar surgeries because you can really isolate your neck after a surgery. You can get to a neck collar and really prevent yourself from turning. But you have lower back surgery, you can't really move without, twisting the lower back. And it's harder to make a fusion work. That's her take. So, if you're having a fusion, multiple level fusion, you're going to be stiff. You're not going to be able to do like that. You're going to be turning your whole body like this. I know a guy who had like a 5-level fusion and he has to turn his whole body. But if it gives you relief, something to consider. I think you just need to talk to the doctor. And the other thing I will tell you is, my opinion, talk to different doctors. Find out what their reputations are. I mean, people call my wife literally every month. Somebody calls to ask about a doctor because she knows all the doctors in Georgia from her comp practice. And there's some doctors who do really good work in surgery. Some of them don't do such good work. So you got to do your own due diligence. Because you saw one doctor doesn't mean that that's the best doctor. And so, it may make sense to get in to see somebody else. The other thing that's going on in the medical world is, at least, near me, is a lot of medical practice used to have a lot of small medical practices. And because insurance companies put the squeeze on those folks, they all join these large practices. So, in Atlanta, for example, there are a couple of very large orthopedic practices. One of them is called Resurgence. One of them is called Peachtree Orthopedics. And, obviously there are many, many doctors there. These practices are very good. But they've also picked up some smaller practices, and the doctors have been absorbed that my wife says, these doctors are not people that I would necessarily want to go to myself. So I think that the quality of the doctors in a practice can really vary. The other thing she says, and I totally agree with this, is, if you're going to go to see a doctor about cervical surgery, make sure that doctor does necks. I mean, orthopedics, some of them do knees or just, below the knee issues. Some of them do shoulders, some of them do elbows. If you have a really, really good knee guy who does great knee work on knees, do you want him operating on your neck? Probably not. He doesn't do enough necks. So you want somebody who does a lot of necks, who is good at it and has good results. So you want to call around and talk to different people. And again, in our case, people call my wife because she knows from workers' comp. So, maybe that's something, if you know any workers' comp lawyers, call them and say, what do you think of, who would you go to if you needed a neck fusion? And they could probably give you some pretty good advice, because that's why people call Jody, and she knows. And you know what? When they take her advice, they usually come back and say, yeah, it was a good decision. Is it okay? That's a good question. Life is like a box of chocolates. Well, chocolate, that's always a good thing, because chocolate is. I have a magnet in my refrigerator that says, chocolate does not judge, and that's right. Chocolate is a good thing, especially if it's good quality chocolate. Nothing better to me than a dark chocolate, 72% dark chocolate that is well made. Again, some of the Ghirardelli, for example, is a really good one. Some of these, ones out of Russia and Eastern Europe are really, really good. And just don't eat too much of it, but it's a real treat, okay, forget about chocolate. I'm gonna get that on my mind. Okay, okay to take your medication. Gabapentin has a habit, as you probably know, of causing some brain fog. They call it GABA brain. So I would tell you, you want to really think carefully about taking gabapentin, or Neurontin is another name for it, before a hearing, because you may not be able to think very clearly. So I would say, excuse me, everything else equal, I would probably tell you I would not. I would tell my client not to. That's just me. Okay, thanks for your help and support. No problem. Hey, Shauna, how are you doing? Tyner, if you receive SSI, why are they saying after the application for SSDI? How old are you, Tyner? I mean, it could be if you're, if you may be able to pursue a disabled adult child SSDI application, or you have income and resources. Now to qualify for SSDI, you have to have an earnings record to be able to pursue somebody else's earnings record. So, there's a lot of unknowns in that question. I don't know why they're asking you that. That could really be the question here. Antonio, thanks from Florida. You're welcome from Florida. I was just down at Miramar Beach. A friend of mine, I think I told you all, I missed a week because of that. I play tennis, as you probably all know, because I'm usually playing tennis on Wednesday before these. Didn't do it today. But a couple buddies of mine, 4 of us, would get on to, friend's got a condo down there, which is nice because it's free. And we play tennis for 3 or 4 days. And so I was just down at Miramar Beach, which is in the Panhandle part of Florida. So yeah, Florida is not too far from here. And it was, probably about 10 or 15 degrees warmer than it is here in Atlanta. Okay, free case evaluation. Sparkle. My grandson needs 3 different resources, in-home therapy. She can't afford to get. I think what she was talking about resources was does your daughter own anything, have any assets, any stocks, any hard assets that could be used to offset, that could be deemed to her, your grandson, that would make him not qualified under a non-medical basis. Tony is at 54. I don't remember Tony's question of fusion. Tony's a question about the fusion at 54. Again, I would really do your due diligence with the doctors, is what I would tell you. Thank you. My pleasure. Clusible. Okay. Yeah, I think that was right. I think it could be she makes too much money. George Graham, will there be more CDRs because Trump enters office? I'm 64. Not for you, George. I think that it's very unlikely that you're going to see a CDR because you're really close to having it switched over to full retirement. So I don't think it's going to happen for you. Will we see more? Very possibly, but we don't know anything yet. Kevin has a depression since age 4. Med's almost gone, but give you man boobs. Too much estrogen. Now that is not a disabling condition. Obviously, I don't be funny about it. It's not a disabling condition, but if you've had it since age 4, the real question that a judge would ask would be, you were able to work for a certain number of years. What has changed? And the long history certainly shows this is a chronic problem. And certainly you could argue that as you've gotten older, it's been made worse. The medications are less effective. But you've got to be able to show why you are not able to work. Deb, they said the SSA phone service, I'm not aware of this. Again, I would start contact Greg at gregbrinkley.org. He might be able to just give you that answer or know somebody who can give you an answer. But yeah, you can certainly ask for a supervisor or make an appointment to go in. By the way, what I'm hearing now is they're going to eliminate all walk-ins. You're going to have to make an appointment. So I would probably make an appointment. Yes, they are synthetic chemicals. You're right, Kevin, and that's that's why they lose effectiveness, because your body gets used to them. Jenny Joe, you are welcome, Jenny. I appreciate that. Derek says Trump tried to cut Social Security benefits every year. Scares me. Talks about cutting government benefits to people. I'm not going to argue with you. I'm not going to argue with you. Okay, Susie says she made a mistake in the application. Possible change. Yes, I do it all. Now, it's hard to change it back. So if you said I became disabled in March of 2023, it's hard to go to the hearing and say, oh, by the way, it was March of 2022. Moving it forward is not a problem. But going back can be a problem. And I would do that earlier, as soon as you can, sooner rather than later, and really probably have your attorney help you with that. Pat, I don't know. I just don't know. I think this is something that, this is beyond my knowledge. I just don't know. Thank you, very true. I appreciate that. I really do. Thank you. I enjoy doing it. It's a lot of fun. I hope it benefits everybody. Troy is 61 years old, been a roofer for 43 years. 2 months ago, had a TKR, total knee replacement, getting the other knee done in a couple of months, waiting for a letter. Filed in March. Should I be good? I think that you could make a pretty good argument that with 2 bad knees, you would be limited to no more than light work. I'm guessing the roofing job is probably not going to have any transferable skills to something lighter. So assuming the knee replacements did not completely give you full functionality back, I think you got a pretty good argument. Yeah, I think so. Deb, I don't know that I would tell Pat to file on the web. I would talk to somebody. You got to do some research on this. Roy lives in California, the roofer in California. You're welcome. Yeah, I think that's a grid rule case is what I think. Although, again, if the knee replacements, there's going to be a period of time where it's going to take a while and you probably are not going to have full functionality, but it really depends on how much functionality you have left and how long you were not able to work. You got to be out for at least a year. So I think that, if you once you've been out for a year, and the fact that you're 61, I think you got a pretty good argument there. Okay, the struggle is rule and deny at 50, the fact that companies desire. Yeah, that's right. That's what the grid rules really talk about, is the grid rules recognize that people who are over age 50 are going to have a more difficult time finding a job in the workplace. That's absolutely right. This is water, by the way, not beer. I don't like beer. In case anybody was wondering. But yeah, that I think vocational witnesses do as well, that it's hard to win when you are over 50, or hard to get a job. American Railroad, again, that's okay. Certainly that's an argument. That's definitely an argument. Thank you, American. I appreciate that very much. Okay, that's how you do the reviews. Thank you. Okay, we just got a couple minutes left here. Okay, and again, these are all ideas that would shore up Social Security. It got to pass muster politically. That's the big issue. That's the big issue. Okay, ALJ gave an extra 30 years to a doctor. Use my hands for the next day, but 2 months. Yes, unfortunately, it is normal, Marvin. It is normal. It can take a long time, even if they get the evidence they need. So Pat, again, I would just tell you, with whatever Deb tells you, I mean, has come up with some really, very insightful comments here, but do your own research and don't take don't take legal advice from Deb or from me or from anybody. You got to make sure either you talk to an attorney for legal advice or you do your own due diligence. So not a knock on Deb, because I'm telling the same thing about me, is you want to be real careful about taking legal advice from anybody on a video. Legal advice is very inherently personal to you. Okay. Thank you, St. Louis, and I thank you again for the $10, much appreciated. Yeah, beyond inpatient treatment, I think there's a lot of ways to go about mental health, and you don't have to have inpatient treatment. Again, you can have a long treatment record from a psychiatrist or a psychologist. What you really want to show is that your mental health condition is very, very severe. Okay, that's part of it. And that it is not really responding to treatment, and that it impacts your functioning on a day-to-day basis, that you would not be reliable at work because you just cannot focus, you cannot concentrate, you cannot be emotionally stable, you cannot deal with work stress, you cannot interact with other people appropriately. All these things. So what are you going to need to show that, given the context that judges see people day after day who are mild to moderately depressed? You got to go beyond that. And I'm saying these are just some things that, in my experience, show that you are kind of beyond that. Can you bring your own Dr. Meadhead asked to the consultative evaluation? Absolutely. Along with your present medication? Absolutely. In fact, I would even tell you, get it to the consultative doctor before your exam. You don't have to wait till the day of the exam. If you have an exam on a Thursday, get it to him on Monday or Tuesday ahead of time. And say, this is before my appointment on Thursday, please review this. And I've seen doctors put in their reports that they had access to this, and it changed what was in the report. So yeah, absolutely. Absolutely. Don't punch holes in your desk or wall. Okay, inpatient treatment is helpful, but it's not absolutely necessary. Absolutely. Okay, this is when we're talking about a person who was on a workers' comp for many, many years. Okay. Thank you, Christina. I appreciate that. And again, very kind words of you. I really appreciate that. Okay, we're going to kind of zoom through the last couple of things here. And this is how to get to get your my account, your my Social Security statement. So, again, Sparkle, I think that, there are some of these things have to be done by calculations, and it's kind of hard to really know what's going on in your daughter's case, in particular, your grandson's case. I would just say this: SSI looks at the numbers, so you've got to kind of fit into their profile. Okay, Alex, you're an SSI. SSDI does not kick in. You can get Social Security retirement at some point, but SSDI is not like a successor to SSI. SSI is because you don't have enough credits. If you're not going to generate those credits, you don't then get SSDI. I have people sometimes say, I'm on SSI, I want to apply for SSDI to get more money. Can't really do that. You have to have enough credits, earnings credits, to fit into SSDI. Okay. Field roast brand makes the best plant device hot dogs. Okay. Okay, well, that's good to know. Anybody want to test that out? I will let my wife know. The Field roast brand is the best for. Okay, you know what? Look how much you learn on this channel. You learn about Social Security. You learn about plant-based hot dogs. I mean, what more could you possibly want? Okay, Herc says, my daughter has schizo personality disorder, been in psych ward for 3 weeks now. She's 15. I can't tell you to apply or not to apply. She would be applying for child SSI. And if you look at the listings, there's different listings for child SSI. The one thing I would always tell somebody is, if you are applying for a child, you're going to label that child as being disabled. And that can have lifelong implications. I would tell you, Herc, talk to your daughter's doctors and see if they think that she is in fact, disabled. And is this something that as she gets older, she may get better, may grow out of it a little bit? again, I just can't say. And then, of course, if she's 15, if you're working, your income might offset her SSI. So it may be all for naught anyway. But I would say tread carefully. Okay. All right. Rick says, okay, that's a good point that, all the stuff that the president says he's going to do, you got to have Congress. Of course, it's a Republican Congress, so they may very well do a lot of that stuff. But, realize people, everybody says, well, Trump's got control of Congress and he can do whatever he wants. All these people in Congress, they have their big egos. They're not going to just be walked over. I think there are going to be certain things that Congress will go along with, but you start cutting social programs, that causes pain. I heard somebody commenting about, they talk about the deportation of people who are not here, not legally. And, some commentator was saying, that sounds great, but then you talk about, you have a person who's here legally, let's say, who's been here for a certain number of, 10, 15 years, but their grandma came in illegally. You're going to deport grandma, who's now 75 years old, who's led a very lawful life, but was here illegally. You're not going to do that. I mean, that's just going to have terrible repercussions. So, politicians, especially, I got to say in this election cycle, both Trump and Harris, told some real whoppers they're going to do this. Let's just wait and see. Let's just wait and see. I mean, we just don't know enough yet. Okay. Appeals counsel sent my case back to ALJ for remand second time, and I have a different ALJ. That's good. That's pretty typical. Pretty typical. I would say, let's see if they deny the claim, and let's see why they deny it. Because again, if it's because of income and resources, it's not going to make a difference, whether you have a lawyer or not, because you're not going to qualify based on that. So I think the first question I would ask is, why is she being denied? And, and is it based on the medical? Is it based on income and resources? Okay. All right, so let's just go through where I'm going to have to fully embrace AI. Okay. Again, I think that AI is coming. How quickly will it be here? I don't know. Okay. Yeah, I'll try to get something out there. And Sharon maybe become my consultant to help me with some of this stuff. So we will see. Okay, that's correct. Okay, very good. Okay, well, Sharon is ahead of me on that because I've never used AI for hearing prep, but we may check it out. Okay, this is Greg at Greenberg. Okay. All right, it is now 2 hours, so I'm going to stop. Those of you I didn't get your questions, just a few I see. We'll try to get to you next week. Again, we're going to have, Dr. Foster on next week. I've also talked to I've talked to a couple of different people, but we're going to try to get, just some different lawyers on, maybe some different doctors, some different attorneys. We'll just have to see who we can get on. And I know, again, I've talked to, there's actually a judge I know, I'm a retired judge. I'm going to see if I can get him on. So yeah, I'll try to get some more guests on just to get some different perspective. Jeffrey Herman and I, we emailed each other earlier today, and I said, you're welcome to come on whenever. So I'll get him on. He's very sharp and he knows a lot about this process, and I think his perspective will be helpful. So we'll try to get a few more guests on so you don't have to look at me the whole time, and we'll hopefully be able to get some good stuff going on. And I think, again, the things that Sharon's talking about, I think are, that's something we can put into action that maybe will help everybody here. So, all right, so for now, that's going to be it for today. I appreciate your tuning in, and I will hopefully see everybody here and more next week for Dr. John Dave Foster, the medical consultative doctor, who will give us his insight about mistakes to avoid and kind of what happens in these consultative evaluations and what Social Security tells them about them. So for now, this is Jonathan Ginsberg, wishing you all the best. Have a great rest of your week, great weekend. Stay warm out there if it's cold where you're at, and I'll see you next week.